everyone. Good morning. Make sure your cameras are on, please. Cameras on, please. Starts. Danny, Juan, Clenard, cameras, please. All right, cool. All right, so good morning, everyone. And first of all, I'd like to apologize for the delay. Luckily, we don't have long classes today. The chapters are not that long, so it's going to be easy. All right. Hey, Valerie. Good morning. How are you? All right, so we've talked about contracts before, right? Now we're going to talk about specifically about conveyance contracts, right? Now, let's start with the meaning of this word. Who can tell me what this means, this word, conveyance? Because we're going to talk about conveyance contracts, even though we already talked about contracts in general. But what is a conveyance contract? What is the difference between this type of contract and a general contract? Oh, well, good morning, Tiana. Tiana for the win. And Valerie as well. Very good. So Tiana said transfer. Very good. Every time you see the word conveyance, remember transfer. Very good. So transfer. So now we're going to talk about conveyance contracts. So that's for the transfer of real estate. Okay. Let's start with contracts for sale of real estate. Right. So a real estate sales contract is a binding and enforceable agreement wherein the buyer, the vendee, agrees to buy an identified parcel of real estate and a seller, the vendor, agrees to sell it under certain terms and conditions. It is a document that is at the center of the transaction. Okay? Now, the conventional transfer of real estate ownership takes place in 3 stages. The first stage, everybody knows, it's that negotiating period. We go back and forth putting offers, counter offers, and all that, right? In an effort to agree to all the transfer terms that will appear in the sales contract. Second phase or stage of the transfer, right, is when both parties have accepted to all the terms. So I made an offer, you accepted the offer, we're good to go. We're now under contract, right? The offer becomes binding sale contract and the transaction enters the pre-closing stage, during which parties make arrangements to complete the sale according to the sales contract terms. And third, the final part of it is the actual closing of the transaction, when the seller deeds the title to the buyer. The buyer pays the purchase price and all necessary documents are completed, so signed and completed. At this stage, the sales contract has served its purpose and terminates. Other names for sale contract are agreement of sale, contract of purchase and sale, and earnest money contract. It could be also binder and deposit receipt or contract. It could be also named offer. The reason why I'm putting here offer is because we just said there's 3 stages to this, right? And in most states of the United States, right, most states, they allow us to prepare an offer, right? We talked about this, which contracts we can prepare or not. We're going to mention it again today. But they allow us to prepare an offer, and if that offer is accepted, then automatically that offer becomes a contract. So technically, an offer is a contract. It's just that the offer is that first stage. Okay, the offer is the first stage. It's negotiating period. Once everybody agrees to it, the offer becomes by itself a contract. Okay, so what is an offer? It's a contract. You got to remember that. What is an offer? It's a contract once accepted. Now, the characteristics of a contract, right, is that it starts by being executory. What executory means, if you guys remember from contracts, from the chapter on contracts, executory means something is pending, right? Executory means pending contract. So I put an offer. There's no validity to it until it's accepted. But once it's accepted, we are under contract, and from the contract all the way to closing, it's a pending contract or executory contract because we're waiting for everybody to perform their respective obligations and promises. At the closing, the sales contract is fully performed and no longer exists as a binding agreement. Now, guys, pending, executory, right? If it's fully performed, what is the term? Who can tell me what is the term of fully performed? So executory is pending. Fully performed. I know. Monday morning, you had the weekend, like long, 4 days without studying, right? Because nobody studied. And now Bruno's asking a bunch of questions. Too early. Get it. All right, no problem. I gave you an extra half hour before we started. Come on. Even Tiana woke up. See? What is the other term, guys? There's executory and there's fully performed, concluded, finished. That's it. We're done. What is it called? Off with the head. What is it called? Sam, we're close? You're in Carteret. You're a little far from me right now. While you guys are thinking, hey Sam, is that a Christmas tree behind you? It is. I didn't know you guys believed in Santa. Same. One for the win. There you go. All right. Boom. Executed. All right. Executed. So when it's pending, it's executory. Okay, pending something. When it's completed, it's executed. Done. Finished. Got to remember these two terms. Now, signatures. All right, you guys are going to hate me this morning. We need signatures on all contracts. Do we need signatures on all contracts? Let me know. Tiana's on point. No. All right, cool. So when do we need signatures? When the contract is in writing, for instance, it requires a signature, obviously. Let me know that this is real. It's two parties, right? Or when it's for the transfer of real estate, most states, because of the statute of frauds, right? Most states have a rule that contracts for the conveyance or transfer of real estate must be in writing, or leases for long term. So if it's in writing, there must be a signature. And the reason why this is not highlighted, as you can tell, is because there's always verbal contracts as well. So I don't want you to think that signature is a feature of a contract. It's not. For a contract to be valid, it must have, if you guys remember, it must have competent parties, right? That means we're 18 years of age or older and of sound mind. It must have offer and acceptance. That means we agree to all the terms. Must have consideration. That means exchange of value, right? I give you the house, you give me the money. And it has to be for a legal purpose. And of course, everybody understands, so it's voluntary. Everybody understands the terms of the contract, right? So a signature is not essential to a contract, but if it's for the transfer of real estate, it must have a signature. So all owners, look at the keyword, should sign the contract. If the sellers are married, then both spouses should sign the contract to ensure that both spouses release homestead, dower, and courtesy rights to the buyer at closing. Failure to do so does not invalidate the contract, but can lead to an encumbered title and legal disputes. What does that word mean? Encumbered title. Encumbered title, what does it mean? Going once. Going twice. Encumbered title. You gotta remember this word. It's one of the weird words that we have here. Encumbered. All right, Tiana says limited. Perfect. So there's a limited title. It's affected title. What we also call it. There's another word, a common word, like today's perfect to talk about that word. Today is perfect to talk about that word. Liens are encumbrances, but not all encumbrances are liens. But Sam, perfect. Liens, correct. The lien for the win. There you go. Tiana, the rainy is good, right? But encumbered, right? Thank you, Celine. Encumbered means cloud. There's a cloud, so it limits. You're right. So there's a limit because a cloud limits what you can do, right? Especially when you're traveling. It limits the speed that you can go at. It limits opening the windows, right? You can blast the music, but nobody else hears. Tough. It's a joke. I just think some people must really like whatever they listen to, and others have to listen to whatever they're listening to. So during summertime, or spring, or even fall, it's the funniest thing. People are blasting music like, hey, I'm in my car. I want to listen to my own music. Please keep yours to yourself. Anyway. All right, enforceability criteria. For a contract to be enforceable, we already talked about this a few minutes ago. Must be valid. That means mutual consent, consideration, legal purpose, competent parties, and a voluntary act. Must be in writing if it's for the transfer of real estate. Must identify the principal parties. Must clearly identify the property, and preferably by legal description, purchase contract price, and be signed by principal parties. You guys ready for the next question? Hey Ruth, good morning. The next question is, oh, too many questions. Whew. Some of you are sweating already. Some of you look mad. It's Monday. All right. Legal description, what does that mean? Hey, Zoom user, change your name. Sinati, I think it's you. Change your name, please. It says Zoom user. Legal description, guys. Meets and bounds, so Celine for the win. We got one. Okay, there's three of them. Three methods of legal description. So we have meets and bounds. What else? What else we got, guys? The lot and block and the rectangle survey. Perfect. Let me show this. Boom. Right here. And Ruth for the win as well. Perfect. So we have the meets and bounds description where the property lines meet and create boundaries. The easiest way to remember. There's the lot and block or the plat method, right? And we have the rectangular survey or the government survey method. Perfect. Right, so these are the three methods of legal description, guys. So every contract must include some type of identification of the property. That identification of the property is pinpointed by legal description that will describe the land where your house is located. So the parcel of land, where is it, you know? All right. Valerie, don't delete messages. There's one thing I hate. I tell everybody. Hate, don't delete messages. Send me something, no matter how bad it is. We're gonna take this outside if we have to. But don't delete messages, because then if it was a nice thing, now I feel like I have to take you outside. Valerie, that's it. We're fighting. No, the point is, doesn't matter what the answer is. If it's incorrect, it's incorrect. I will address it. There's no like wrong answers, but I will address it if I feel that I need to or that I haven't explained it yet. Okay. So Valerie, never delete messages, please. All right, next, written versus oral form. As I said earlier, not all contracts have to be in writing, but I have here in green. A contract for sale of real estate is enforceable only if in writing. If it's for the sale of real estate, must be in writing. It's not that an oral contract is not enforceable, right? It is valid. It's just tough to enforce unless we have, you guys remember statute of frauds, unless we have clear and convincing evidence of the intention of the parties. Difficult to enforce. All right. Assignment. What is the word assignment? Right? If I assign a number to you, I'm giving you a number, right? I'm transferring you something, right? In an assignment, when you see assignment, right, is I put it under contract and I say, you know what? I'm not ready to buy, or I can't buy, or whatever the reason might be, and I assign or transfer the contract to somebody else. But what am I transferring? I'm transferring the rights to the rights and obligations to the property. So assignment in today's day and age, I mean, it's always called the same, but in today's day and age, we commonly know it as wholesaling. That's when investors or first-time investors, they put it under contract, right? For real estate exam, don't worry so much about it. It's just, I just want to point it out what happens. What makes it legal for wholesaling to exist for people without license to make money off a transaction is through an assignment. I put an offer on the property, right? And because I put an offer, I'm a party to the contract, right? What I'm doing is, once I'm a party to a contract, what I'm doing is then transferring or assigning the sales contract to another party. That means the other party has the right to purchase, but also has the obligation to purchase. Okay? Who may complete contracts for the conveyance of real estate? Broker or an agent may assist the buyer and seller in completing an offer to purchase, provided that the broker represents the client faithfully and does not charge a separate fee for the assistance. So attorneys prepare contracts, we get it. But in the regular transaction, residential, for instance, we can participate and we cannot charge extra for it. It is advisable and legally required in most states for a broker to use standard contract forms promulgated by the state agencies or real estate boards, as such forms contain generally accepted language. This relieves the broker of the dangers of creating a new contract language, which can be construed as practice of law for which a broker is not licensed. So the reason why we can fill in the blanks on standard contract forms created by your state, okay? The only reason why we can do this is because we're not practicing law. We're literally just filling in the blanks. The problem is when you start answering questions that are law related. This is when, you guys remember watching the video with Terry Watson, Not My Monkey? This is when we say, well, like, hey, that's a legal question. We need to bring this to the attorney, and the attorney will reply that question, all right? So never give legal opinions. One thing is giving your opinion, professional opinion regarding the house. your opinion regarding the weather, right, doesn't affect the contract itself. Your opinion about the house will, your opinion about the weather will, the transfer, but not the contract itself. So any changes to the contract or any addressing of the terms of a contract has to be followed up by an attorney. So very careful with that. Offer and acceptance, you guys already know what this is. It means that we all agree to it. If there's a counter offer, it's a rejection. We cover that. What is the difference between equitable title and legal title? Does anybody know? You guys remember? Equitable versus legal. What is the difference between these two? Who can tell me? Zaline, yes, it has to do with ownership. Sorry, hold on. I forgot to post this. So Sam says, the Not My Monkey video. That video really helps me every time someone asks advice for family matters. I just tell them, I just tell myself, not my monkey. Yep. It works. It works. I have somebody that actually, that's exactly how they speak. When somebody asks them a question, they go like, not my monkey. Not my monkey. Nope. And then people are like, what are you talking about? Okay, so show them the video. Still waiting on the answer. I only got ownership from Zaline, but there's more. The difference is ownership. Great. What kind of ownership? Because they're all ownership. Both of these are kind of ownership, but what's the difference between them? It's related to ownership, yes. Legal versus equitable. Monday morning, rainy day, you guys are going to hate me. I know. There's way more questions coming. Because we already talked about contracts, that's why. Alright, so the difference, legal versus equitable title. Legal title, look at me. Legal title means that my name is on the deed. Equitable title, that means either I put money or some type of consideration into the property. So, legal, my name is on the deed. I'm the owner of record, okay? Owner of record. When you search title, my name is there. Equitable is, for instance, when I put an offer. When I put an offer, during that executory period, okay, until we close, I have ownership based on equity, okay? I have ownership. What does that mean? It means that you cannot sell, okay? Seller, the one with the deed, with the owner of record, legal title, cannot sell until I release this. Until I say, well, I'm not buying anymore, okay? Until I say I'm not buying anymore, right? I have equitable title. The same thing with a lease with option to buy. When you lease a car, can the dealer sell the car to someone else? If you're leasing a car, guys, let me know in the chat. If you're leasing a car, can the dealer sell the car to anybody else while you're leasing the car? Great. The answer is no. Why is the answer no if I only have a lease, if I'm only renting? The thing is, guys, we put the option to buy. We put the option to buy. That means we tied into a contract. Therefore, we don't have legal title. We have equitable title. Okay? You're tied into a contract with me. You cannot sell to anybody else until either I release the title or we conclude the transfer. Okay? So equitable title says right here, look, All right, Ruth, I was seeing your answers, but I just wanted to finish the explanation. I'm glad you got it. So, perfect. Equitable title. A sale contract gives the buyer an interest in the property. They're not the owners, but it gives them an interest in the property. That is called equitable title or ownership in equity. If the seller defaults or backs out of the contract for no reason, right, then the buyer can show good faith performance, meaning I did what I needed to do on my end. You're the one seller, you're the one failing, right? So now I can sue you for specific performance. What is specific performance? That means I'm going to compel or force the seller to transfer legal title. Specific performance. Seller, you're supposed to sell to me. So I'm going to force you to perform the specific terms of the contract, which is you are selling and I am buying. Okay? So I have that right because I have equitable title. Okay? It's different from a lease. A lease, I'm just renting. The seller, the landlord, can sell to whoever they want. But a lease with option or a contract for purchase, right? And the option is a contract for purchase, right? The lease with option or contract for purchase tie the seller in such a way that if they default, if the seller defaults, if the seller says, no, I'm not selling, the buyer can sue for either compensation or for performance of the contract. Right? Give me a thumbs up if you guys got it. Okay? All right, cool. Don't forget to ask a bunch of questions if you have doubts. All right, next we have earnest money escrow. Earnest money escrow. What does this mean? Well, earnest money escrow or earnest money deposit or good faith deposit. These are similar terms. Okay? Earnest money deposit or good faith deposit. It's money that must be set aside. That's why it says escrow. Must be set aside to cover defaults. Right? Defaults by who? Well, by the buyer. So the buyer gives the earnest money deposit to an agent or to the seller or to whoever it is in the contract, stipulated in the contract, right? They give them money, right? Like a secure deposit on a rental. If you damage the house or if you break the lease terms, right, then the landlord can keep the money. Well, the good faith deposit or earnest money deposit, it's very similar to that, where if the seller backs out, there's no money to be transferred, but the buyer can sue. But if the buyer backs out, the seller can keep that money. So if I put $5,000, if I put $5,000 as a good faith deposit and the buyer backs out, the seller can say, okay, well, I'm keeping your money then. I'm not returning any of the money. See, the seller has two options. They have the option of either keeping the money or suing for more. Okay? If the buyer concludes, like if we go to the closing, then the deposit is applied to the purchase price. Purchase price. Okay? So usually goes towards the down payment, but it's applied towards the purchase price as a credit. Any questions? Oh, who puts a good faith deposit? The buyer. The buyer does. Just like like I said, just like a lease. The tenant comes up with a good faith deposit. It's called a secure deposit there, but it's the same thing. Okay, good faith deposit, earnest money deposit means all the same. Okay, it's money that needs to be set aside and waiting, just like your secure deposit, set aside because it doesn't belong to the seller, doesn't belong to the mortgage company, doesn't belong to anybody other than the buyer. Just like the secure deposit on the rental belongs to the tenants, not to the landlord, right? So it's money that's set on the side. That's why it's called escrow. It's put aside, separate account. that says if you conclude the terms of the contract, if you follow through, buyer or tenant, if you follow through with the terms of the contract, then this money that's set aside is going to be released to you at closing. Okay, but it's the buyer that puts that money. All right. Next, contract contingency. What does this word mean? Contingencies, guys. What does that mean? Contingencies. Take your time, one at a time. You don't have to reply all at once. Don't worry about it. Contingency keeps going. Okay. I'll hold on to that thought. YouTubers, you guys are watching, participate. What does the word contingency mean? Zoomers, contingency. Denitza, Marta, come on, Nydia, Sam, Riza, Celine, Alexis. Guys, participate. What's going on here? What does contingency mean? Juan, what does contingency mean? Danny. Come on. Ophelia Clenard, waiting. Meredith, Sonia, you're there. Shanice, you're there. Contingency. I got you. I'll answer that. I just want to make. I just want to see more coming through. No Googling, okay? Just straight answer, whatever you feel like. Yana, don't get mad. All right, Ruth says, action. Valerie, if you're still there or whoever else is watching, I see there's more people watching. Participate as well. There's no wrong answers. All right, let's see what answers we got here so far. Okay. Donna says, it keeps going. Like the Energizer Bunny, right? Something that must be done or provided. Okay. Condition. All right. Under review, maybe. What else? To fulfill contract. Okay. Condition, 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 condition. That must be met before contract is enforceable. All right. So, contingency. Contingency, guys. Conditions. Okay. So, I want you to think about this. Okay, it's called conditions, by the way. There's another word for it. You could hear it here. Another word for it is subject to. All right. So, when you look at contingencies, think about this. I'll buy a house. Yes, Ruth. I'll buy your house, Mr. Seller or Mrs. Seller. I'll buy your house if I get approved for the mortgage. That if, right? That if creates a condition. Sanadi, change your name, please. You're back to Zoom user. So condition means if. I'll buy your house if I get approved for a mortgage. What if I don't get approved? Okay. I buy a house if the inspection is favorable. Like once I check the inspection report, right, and I like it, we'll move forward. If there's something I don't like about it, if it's too expensive to repair, whatever it is, I back out. So a contingency equals if there are certain conditions that will subject this contract to my purchase, right? So will I buy? Yes, I will buy if all these conditions, which this contract is subject to, right? If all these conditions are met. If the conditions are not met, what can I do? Legally, I can walk away because it was a contingency, because it was a condition to it. You guys understand? So every time you see contingencies, you got to think of conditions or if. if this happens, I will buy. Simple as that. So a contingency, it was right there. A contingency is a condition, that must be met before the contract is enforceable. Contingency is a condition or an if that must be met before the contract is enforceable. Okay. All right. It is possible for both the buyers and sellers to abuse contingencies in order to leave themselves a convenient way to cancel without defaulting to avoid problems. The statement of a contingency must be or should be explicit and clear, have an expiration date, expressly require diligence and in the effort to fulfill the requirements. For instance, the expiration date. We're going to subject to the inspection, right? Within 10 days, for instance. So we're giving 10 days after the contract is enforceable. We're giving 10 days for the inspection to happen, right? Not going to wait here 3 months for the inspection to happen. We'll give X amount of days after that for you to give the second deposit or first deposit or whatever it is. Like, everything must be explicit in the contract. A contingency that is too broad or vague or excessive in duration may invalidate the entire contract on the grounds of insufficiency of mutual agreements. All right, a sales contract is bilateral. We heard these terms before, right? What is bilateral? What does this mean, bilateral? We're going to repeat all this in the final week of the class too, so you guys know. Bilateral, what does it mean? Bruce says 2 people. Okay. Alexis says relating to 2 sides. Both parties agree. Both parties, okay. Nady, anything to say regarding bilateral? All right. Raphaelis says, okay, Tiana says both parties do their part. Raphaelis says both parties to perform. Lily says agree, and then it says no. And Ruth says yes, but she said. Those are always great answers. Like, hey, whatever she said there, it's fine. I'll just go with it. Right? Just remember, Ruth, when you go take the exam, you cannot go like whatever she said, okay? But yes, bilateral means both parties promise to perform. Okay? And here you go. There you go. Just agreement, just an agreement. Okay, let me address this. And this is the reason why guys, I like you guys to participate. Like Ruth, it's not an agreement by 2 people. It's not just both parties to agree. Think about this. A unilateral agreement, unilateral, is also where 2 parties agree. So the agreement is not what makes it bilateral or unilateral. Is what type of performance they have to make. See? Right here. Both must do their part. Most must perform. Both parties must agree to perform. Very important. So when we're talking about bilateral, right, means that both parties must do something in order to close. Unilateral, like a lease with option. The seller must sell, but only if the buyer says a year later or 2 years later, whatever the lease term is, right? if the buyer says, hey, seller, I'm ready, I want to buy, right? So there's an if there again. That's the unilateral. A bilateral, there's no if, is both of us must do something. The only if is contingencies that are external to the parties, like the mortgage, the inspection, and so on. But a bilateral contract is both parties promise to perform. As a result, either party may default by failing to perform. And note that a party's failure to meet the contingency does not constitute default, like I was saying, but rather entitles the party to cancel the contract. So, again, bilateral doesn't mean both parties agree, because any contract has to have agreement. Okay? Bilateral means both parties must perform, must do something. So the seller must sell, the buyer must buy. There's no if here for one party or the other. Okay? That's what it is. If the buyer defaults, the usual remedy right here is for the seller to keep the buyer's deposit as liquidated damages. What is the word liquidated damages? It's a settlement. So every time you see liquidated damages, settlement. That means I'm keeping your money as a settlement. I'm not going to sue you for more. I'm keeping it as a settlement. If I want to sue for more, right? So if I want to sue for an excess of the money that's there, then I can have one or the other. So I can sue for more money if I want. But usually, liquidated damages, that means I settled. All right. Now, if a contract does not provide liquidated damages, the seller may sue for damages, cancellation, or specific performance. If the seller defaults, if the seller is the one that backs out of the deal, right, then the buyer may sue for specific performance, damages, or cancellation. Same thing. All right, sales contract provisions. This is common sense. We already talked about it. It must identify, so I'm going to fly right through a couple of things here. So a sales contract must identify the parties, the consideration, and the property through the legal description, right? We already talked about legal description. It must include a clause that states the final price and the details of how the purchase will occur. It is important for all parties to verify the buyer's earnest money deposit, down payment, loan proceeds, and other promised funds together that together they equal the purchase price stated in the contract. Loan approval, earnest money deposit, escrow, closings. So we already covered most of this. Gonna skip. And just a quick reference again, we're on page 200. Quick reference, during the transaction we need to pull a report. We don't do it, insurance company will do it, but a report called CLUE, Comprehensive Loss Underwriting Exchange. And the CLUE report gives us a claims history on the property for the past 5 years. It's like, this is the equivalent to Carfax. So let us know if there's any claims against the property. All right. It shows the 5-year insurance loss history of the property. All right. So if there's a question in the state exam that says, or the school exam that says, how can you know incidents or insurance claims in the past 5 years? And they're going to give a few options. 2 of them are very similar. One of them is going to say CLUE, but it says the whole thing. It says Comprehensive Loss Underwriting Exchange. The other one, the acronym is going to be CLE. And it's the same thing, but instead of underwriting, it will say insurance. And I'm pointing this out because the question is, which report shows you insurance claims that happened against the property within the past 5 years? Okay? You guys understand? So they will ask you what are insurance claims, and your brain, the first thing that does is associate, well, if it's an insurance claim, then it's a comprehensive loss insurance exchange. No, it's not. It's not insurance. It's underwriting. So if this question pops up, most of you will click insurance. It's not. It's underwriting, because underwriting means risk assessment. But don't worry, if you guys have no clue what to answer, if you have no clue what to answer, just look for whatever matches the acronym CLUE. That's all. If you have no clue what to answer, look for the acronym CLUE. Okay? Besides, CLE doesn't even sound right. Think about it. Like ballet or something. You're doing plie, right? This is plie over here. Doesn't even sound right. So CLUE. If you got no clue, it's a comprehensive loss underwriting exchange. Underwriting. Underwriting means risk assessment. So what they're doing when they're pulling the insurance report is they're checking, hey, what has happened to the property in the past 5 years? Can we insure? Is it insurable? What are the risks? Just like they do when they check your driving record, right? Your credit report. They're trying to figure out who you are and should they insure you. That's what underwriting is. Ruth says, I never was taught this. Yep. I'll teach you the things you need to pass the exam. I can guarantee you that. If this question pops up, which has popped up in a few exams, you'll know. All right, next. All right, addendum are additions to the contract. Additions to the contract. And we could be agency disclosures addenda. That's the cover page that says I represent you as a sales agent, buyer's agent, dual agent, whatever. Liquidated damages, that's the earnest money or good faith deposit. If it's in the flood zone, so these are additional pages that are going to be added to the contract for specific purposes. Okay, these are addended. All right, guys, we already talked about the option to buy contract. We said it was the lease with option to buy, also known as rent to own. Okay? And I always say that this is similar to a car lease. Again, because at the end of the renting period, you have the option to own the car. Same thing with a house. You have the option to own a house. So an option to buy contract is the same as lease with option to buy. It's the same as rent to own. Think of it as a car lease. You test drive it for 3 years. You test drive the house. If you like it, at the end you buy. If you don't like it, walk away. Simple. So an option to buy is an enforceable contract in which a potential seller, the optionor, grants a potential buyer, the optionee, the right to purchase a property before a stated time for a stated price and terms. In exchange for the right of the option, the optionee pays the optionor valuable consideration. So it's like a down payment, right? So if I'm purchasing an option, I'm giving you a down payment, which is a commitment to later on purchase the house, all right? All right, so the buyer, the option to buy places the optionee, the buyer, under no obligation to purchase. However, the seller must perform. What type of contract is this? If the buyer has no obligation, but the seller has an obligation, what type of contract is this? Is it bilateral or is it unilateral? One party must do something. So the buyer is not obligated to perform, but the seller is. What type of contract is it? Is it bilateral or unilateral? Unilateral. Great. Perfect. The seller has to sell, but the buyer, the optionee, is under no obligation to purchase. Again, just like a car lease, no obligation to purchase. Okay. I want to point this out real quick here. It's not as important for the exam, but if you guys ever get into a rent with option to buy, if you guys ever talk to somebody about that, or actually get involved, which we can, as agents, we can get involved. We don't prepare these contracts, but we get the commission on the rental and the commission on the sale, so it's great. But what I want to point out is that this depends on the states. There might be a little difference, but an option to buy must include an actual non-refundable consideration. Non-refundable. So if I give you $5,000 for that option, it's non-refundable. The option must require the optionee to pay a specific consideration that is separate from the purchase price. The consideration cannot be refunded if the option is not exercised. Right? So that's the protection for the seller. If the buyer at the end of 3 years does not buy, the seller keeps that money. Simple. If the option is exercised, then the consideration may be applied towards the purchase price. So again, it's like that deposit, the good faith deposit almost, right? If I don't buy, like I'm not obligated to buy, but if I don't buy, the seller keeps the money. If I do buy, then not do buy like buy the vacation spot, but if I do purchase, okay, then they take that option money and dump it into or credit towards the purchase price. In some states, this part is mandatory. Some states, this part is mandatory. They ask that a portion of the lease, okay, a portion of the lease, like whatever you're paying monthly, a portion of it goes towards the purchase as well, right? So in some states, they don't care. Like, hey, whatever you're paying in the lease belongs to you, the landlord, right? Whatever is being paid in the lease belongs to the landlord. In other states, like here in the state of New Jersey, for instance, they ask that a portion of the rent has to qualify towards the purchase. Hey, Rose, good morning. All right, this option must include, because it's a purchase agreement, must include the price and sales terms, have an expiration date, meaning it's valid for 3 years, just like a car lease. It's a 3-year lease. You rent for 3 years, but at the end of 3 years, you got to make a decision. Same thing. It must be in writing. All right, right here, must be in writing, okay, because of statute of frauds. And it must include a legal description, which you guys already know by now what it is. Must have the general contract validity requirements. That means everybody's competent. There's promises between each party. There's consideration, all that good stuff. Okay. All right, we're going to move on. This one. Legal aspect. You guys already know equitable interest. So this is for the option agreement. The buyer has equitable interest, right? The seller cannot sell until the buyer says, I want it, I move forward, or I'm backing out of it, one or the other. Okay. Now, contract for deed. The option agreement is similar to a car lease. A contract for deed is similar to car financing. It's the same thing as or it happens the same way as a contract financing. You're paying principal and interest, right? You're paying principal and interest, but when do you get the title to the car? When you finish paying it off. So a contract for a deed, also known as installment, sales contract, okay, also known as a land contract, is where the seller says, instead of leasing, the seller says, look, I'll be the bank. Instead of going to Bank of America, give me a deposit now. I'm the seller, you're the buyer, right? Just give me a deposit now and pay me in installments over the next 30 years at an interest rate of 5%. Okay? So over the next 30 years or 15 years or whatever term we decided, the buyer pays principal and interest. Okay? The key difference between a lease option and a contract for deed is that a lease option is a rental with an option to buy, right? Where contract for deed, there's financing created between the buyer and the seller. So there's interest involved, interest, okay? So over the years, you pay, and then the seller releases the deed to the buyer. That's why it's a contract for deed. It's almost like a layaway, right? Almost like a layaway, but they let you live and use and occupy and maintain the property. The layaway. They only give you the deed or title to it later on. Any questions here? Okay. I just explained all this. This is the part you need to remember. At the end of the period, the buyer pays the vendor the full purchase price, and the vendor deeds the title, the key, at the end, deeds the title to the vendee. So after 10, 20, 30 years, whenever we finish paying it off, just like in the car, right, it's when the title is released to your name. Give me a thumbs up. Okay. Great. Interest and rights. Cover that. Legal form. Cover that. That is it for this chapter. We already covered everything here. Let me know if you have any questions before we stop this session and go to the next chapter. If you have questions. It was just an overview. We already talked about contracts before, so it's just a little bit more detailed when it comes to conveyance or transfer of real estate. All right. If you have any questions, just wave your hand in the air. Like, don't. Okay. All right, Sam. Sam, if you have a question, write it down. Or you're waving just because you wanted to wave. You don't care. That was it. All right, guys. So if there's no questions, I'm going to end this session. It's 11:30. We will be back in 10 minutes. So 11:40, we'll be back to do chapter 15. If you think of any questions, make sure you bring them in the next session. YouTubers, I'm going to end this one. I'm going to start a new one right after, okay? See you guys in a little bit.